Hi guys, welcome to another session of News in 30 Minutes. Today we will discuss a few important issues on 18th of October. Many issues are happening in the realm of international affairs, in the realm of polity and governance as well as environment. So you should have a keen eye on these issues. Okay, for example, West Asia is in news, so you should have a very keen eye on different places that are in news in West Asia. In polity and governance, there is electoral bond scheme that is in news. Now there is Special Marriages Act that is in news. There is Child Adoption Resource Authority that is in news. So when such things happen or when these things are in news, it is always good to just Google about these institutions or these issues and read about it a little bit in detail. That extra step of curiosity is what will help you get that one statement correct in your prelims exam. Okay, so please have that inquisitive mindset when you come across these institutions, these issues in the newspapers. Okay, so with that, let us get on with the first issue of the day. The first issue of the day is the Supreme Court says it cannot legalize the same-sex marriage. Okay, now this is a judgment that has a lot of other branches in it. So let us decipher what exactly is this judgment and what are the other things that Supreme Court has brought with this. Okay, the first is the judgment itself. As you can see, by a 3-2 majority, the court has declined to grant constitutional protection to civil unions of queer couples. Okay, so the civil union of queer couples is not granted any legality under the Special Marriages Act of 1954. So what is this all about? See, this Special Marriages Act 1954, the petitioner had filed that Special Marriages Act 1954 must be interpreted from a gender neutral angle. So let me explain what it means. It means that, see, this Special Marriages Act is a secular legislation. It is a secular legislation. It allows inter-caste as well as inter-religious marriages. Okay, so it gives that legitimacy to inter-caste as well as inter-religious marriages. Okay, so the petitioner's request was to read same-sex marriages under the Act of Special Marriages Act, that is to make sure or to interpret Special Marriages Act in a gender neutral angle. In that way, same-sex marriages can also be considered under the ambit of Special Marriages Act. This was the petitioner's request. However, as you know, the judgment says that they cannot grant constitutional protection under Special Marriages Act. The Chief Justice of India has said that they cannot strike down SMA, that is, they cannot strike down Special Marriages Act, nor can they read the provisions of Special Marriages Act differently. This is the statement given by the Chief Justice of India. They cannot strike down Special Marriages Act, nor can they read the provisions differently. The changes that need to be made in the Special Marriages Act to accommodate the same-sex marriages from the legislative domain. This is the judgment that is given. So the judgment is making sure that the rules are changed from the legislative domain. This shows a sign of judicial restraint. Correct? So this is what the judgment is, and this is what the Special Marriages Act is all about. Okay, so this is one. The next is, as you know, the judgment came with a 3:2 majority. Okay, so 3 people not favoring the constitutional protection for queer couples, whereas 2 favoring them. However, when you take right to marry, okay, all the 5 judges agreed unanimously. All the 5 judges agreed unanimously that right to marry is not a fundamental right. This is very, very important. Right to marry is not a fundamental right. So they say it is no qualified right to marriage. There is no qualified right to marriage. That is what is the statement given. So right to choose is a fundamental right, but right to marry is not a fundamental right. So the queer couples cannot claim right to marry as a fundamental right. So that is the consequence of this decision. So this is about the right to marry. The next is marriage as an institution. Several judges in the Supreme Court have given different versions of what marriage is. The reason you should know a few of this elaboration is because in your paper 1 you have salient features of Indian society, and one such salient features is marriage being a social institution. So in that way you should know some elaborations and interpretations that the judges have done on this phenomena or on this institution called marriage. Okay, so look at this. I have written a few interpretations that is very good that you can use in your answers in your society. One, Justice P.S. Narasimha says that marriage is a social institution in our country that is largely conditioned by culture, religion, customs and usages. I'll repeat again. Marriage is a social institution in our country that is conditioned by culture, religion, customs and usages. So basically, Justice P.S. Narasimha told, when I read the entire interpretation of the judge, I read that what the Justice P.S. Narasimha is trying to tell is the marriage during the colonial period got codified. It got its legislative dimension during the colonial times. Now, before the colonial times, marriage as a social institution had its rules that was formed from culture, religion, customs and usages. That is what Justice P.S. Narasimhan is trying to tell. Hence, marriage is a social institution that cannot be looked only from the legal angle. It is a complex phenomena that is conditioned by different sections like religion, culture, customs, traditions, etc. This is the interpretation of what marriage is. Okay. The next, the Chief Justice of India has also interpreted marriage in different ways. One, the Chief Justice has said that marriage is not static. From sati to interfaith marriages, the institution of marriages has undergone a sea change. So constantly, this marriage is undergone, refining. It has undergone the forces of modernization to weed out unnecessary and regressive practices and to inculcate progressive practices. Okay, so that is what the interpretation is. Marriage is not a static phenomenon. The next is, there is no universal conception of marriage. It is understood differently in law, differently in religion, differently in culture. Some religion consider marriage as sacrament, and while others consider it as contract. Okay, so these are all different interpretations. There are many more interpretations that is done, which is very good. If you want, you can read it through in a lot of headlines in many newspapers. Make a note of it, because this you can use in your answers, especially in Indian society. Okay, so this is the overall interpretation of marriage in this particular case. Okay, the next is transgender rights. This is again a progressive judgment that has been given. In this judgment, they have recognized that gender is different from sexuality. So basically what they have told is they have recognized transgender rights by allowing heterosexual couples can marry under Special Marriages Act. So what they say is, if a trans woman and if a trans man wants to marry, then this will have a constitutional protection under the Special Marriages Act. So they recognize the right for heterosexual marriages of transgenders. I hope it is clear. They are recognizing the heterosexual union of trans man and trans woman under Special Marriages Act 1954. So that is another interpretation, that is another consequence of this judgment. Okay, the next is the Chief Justice of India also made it clear that queer is a natural phenomenon. Okay, there are a lot of perception within the society that queer is something that is confined only to urban areas. In rural areas, there is no such phenomena as queer. There is also some perception that queer is mainly in elitist hierarchy. When you come to the poor and downtrodden or middle class, there is no such phenomena called queer. Okay, so to mitigate this perception, the Chief Justice has made it very clear that queer is a natural phenomena and it is not exclusive domain of urban or elitist. Okay, that is another outcome. This will again help in removing the stigma or perception, biased perception that is there within the society regarding the LGBTQ community. The next is, the Supreme Court has also given several safeguards to end discrimination amongst queer couples. Okay, one, the Supreme Court has announced a series of guidelines how it instructs the police what to be done, how it instructs the public what to be done, how to sensitize people about them, how to make sure that their rights are preserved, how instructions are given to the government to help them, in terms of entitlements. So these are a few guidelines that are given by the Supreme Court. The next is the Supreme Court has also set up something called a committee, and this committee will be headed by a cabinet secretary. So this committee is mainly in charge of identifying the scope of entitlements. It will be mainly in charge of identifying the scope of entitlements for queer couples. Okay, so this is the overall judgment. One, you understood the judgment that they will not receive any constitutional protection. Special Marriages Act is a secular legislation for interfaith as well as inter-caste marriages, but it cannot be interpreted in a gender neutral manner. It will not be struck down, nor they cannot be read it differently. That is what the CJI has told. The next is the right to marry is not a fundamental right. Fourth is marriage is a wide area of interpretation with a very complex phenomena in India. It is not purely looked from legislative domain, but it is a complex phenomena that is mix of traditions, customs, religion, culture and usages. So this is what is marriage in India. The next is transgender rights. Gender cannot be equated to sexuality. The heterosexual couples of transgenders can get married within the Special Marriages Act. The next is queer is a natural phenomenon, not exclusive domain of either elitist or urbanism. And the last is the safeguards provided to end discrimination against queer couples. Okay, a committee has also been set up, which now becomes very important of what decisions these people take to provide the scope of entitlements for these queer couples. Okay, so this is what is the first issue of the day. Now, as a conclusion, one thing what you should know is this case shows judicial restraint. The Supreme Court could have easily gone into the Special Marriages Act. They could have proactively taken measures to change the rules within Special Marriages Act. But now the Supreme Court has shown judicial restraint and it has given the powers back to the legislative domain. This is what the government had claimed in the Supreme Court. The government had told that whatever rules we have to make on marriages falls in the exclusive domain of the legislature and not the judiciary. Hence, it has to be left to the legislative domain, and the Supreme Court has allowed whatever the request the government has made. This is a very good example of judicial restraint. Finally, Justice P.S. Narasimha says the impact of legislative framework on the benefits of LGBTQ must be done through deliberative and consultative exercise. It cannot be a one-stop approach. It cannot be a top-down approach. It has to be deliberative and it has to be consultative. So this is what the entire issue of the day. Now, within the same within the same case, there is another branching out of the interpretation. That is the next one. Let us see this. Supreme Court is divided on allowing unmarried couples to adopt children jointly. Okay, so it is divided on allowing unmarried couples to adopt children jointly. Here, the Chief Justice of India held that Regulation 5 of 3 of the adoption rules are ultra vires to Juvenile Justice Act and the violation of fundamental rights of queer couples. This is what the CJI had told. One, the CJI has told that the regulation of this adoption rules is unconstitutional. Let us see why the Chief Justice of India tells that. However, when the Chief Justice of India tells that, the Chief Justice of India tries to void that particular rule, but other judges, that is the other judges that are given here, they make sure that the regulation is not void. That is why the title reads that the Supreme Court is divided. Let us see what this exactly means. But here there are a few institutions that comes which you should know. Okay, for example, I'll get to that. The next heading here reads Supreme Court, unmarried couples and queers cannot adopt. It is true that they cannot adopt. Okay, so that is there. So the Supreme Court may be divided on the interpretation, but one thing is for sure that unmarried couples and queer cannot adopt even now. Okay, so there is no change of rules. Queer couples cannot adopt as well as unmarried couples cannot adopt. That still stands. Okay, now let us see what the issue is all about. So here, as you can see, the Chief Justice of India is pointing to a regulation called 5 of 3 under CARA Act. Okay, now the CARA Act is Child Adoption and Resource Authority. Okay, this is the CARA, Child Adoption Resource Authority. This is an independent authority under the Ministry of Women and Child Development. Okay, and this particular Child Adoption Resource Authority is in charge of inter-country as well as in-country, that is inside the country. It is in charge of inter-country as well as in-country adoptions. Okay, so CARA has made certain regulations in order to regulate adoptions within the country as well as between the countries. Okay, so let us see what this regulation 5 of 3 is about. As you can see, the regulation 5 of 3, okay, it reads like this. It excludes unmarried couples from adopting by prescribing the condition that the couple must have been in 2 years of stable marital relationship. This is what it reads. So basically, by prescribing that adoption can be done by only those who are couples who are married and they are married for 2 years. So when this is done, the Chief Justice of India has asked several questions. Let us see what the questions are. One, the Chief Justice of India interprets this provision. This is from CARA Act. Correct. So the regulation 5 of CARA Act, this provision is ultra vires with the section 57 of Juvenile Justice Act 2015. Okay, this is what the Chief Justice of India tells. The regulation 5 of 3 of CARA Act is ultra vires with section 57 of Juvenile Justice Act. The reason why Chief Justice of India tells that is, in Juvenile Justice Act, there is no impediment. There is no impediment for adoption by non-married couples. There is no impediment for adoption by non-married couples. So in one act, you are telling that the adoption can be done from non-married couples angle. Now in CARA Act, the regulation tells, the adoption can only be done by the couple who have 2 years of marital relationship and the 2 stable marital relationship. This is contradictory. Hence, it can be ultra vires. This is one reason. The second reason the Chief Justice of India says is, this particular regulation is pointing out that only heterosexual parents are good. Only heterosexual parents are good. So non-married couples as well as the queer couples automatically become bad then. That is what this regulation says. That is one. The next is, the Chief Justice of India asks stability. How is it that you know that marital heterosexual couples will have stability? How it promises stability automatically? So there is no data regarding this. Okay, so in these 3 ways, because of these 3 things, the Chief Justice of India tells that this provision is ultra vires. Okay, that is the reason the Chief Justice of India tells it's ultra vires. So when the Chief Justice of India tells that this has to be, this regulation has to be void, now the other justice, okay, they say that they again this particular regulation is still active. The reason is, though Chief Justice wanted this regulation to become void, other justices will not make it void. They say that it is up to CARA. They are given the liberty. They are given the liberty to the Central Child Adoption Resource Authority. They are given the liberty to CARA to make sure that their provisions will best serve the interest of the child. Okay, the provisions should best serve the interest of the child. That is one thing that they have told. And also, one of the justice of Supreme Court has told that CARA, that is Child Adoption Resource Authority, this authority must also take the realities of the day in order to make the provisions. This the justice has told because there is there is a rise and spur of de facto families. When de facto families are on a rise, we have to take the realities, what is happening in the society, to frame provisions. So, though the Chief Justice of India wanted to declare this regulation void, it is not done so, because all the other justices will say that let me give the authority the chance to make sure that the provisions are changed so that it is given in the best interest of the child, and also this provision should reflect the realities of the society. Again, this is an excellent example of judicial restraint. Okay, so this is about adoption rules. Overall, you should have a very good idea about Special Marriages Act. You should have a very good idea about what is Central Adoption Resource Authority and CARA Act, and also you should have an idea about Juvenile Justice Act of 2015. This may come both in your prelims as well as your mains exam. So have a good idea about this, guys. Okay, so this is the second issue of the day. The next issue of the day is an article that talks about when tigers and jackals get a same protection. Okay, basically this article is giving the challenges to the recent amendments done to Wildlife Protection Act 1972. That Wildlife Protection Amendment Act is what this article is mainly focusing on. So though the article will not go into depth of what this amendment is, I am going to tell you people what is the depth of this amendment, what are the challenges to it. Okay, again, Wildlife Protection Act has always been important and it's a running theme of UPSC in prelims, so you should have a very good idea about what is Wildlife Protection Act. So since it is amended, now you should know what are the amended provisions of Wildlife Protection Act. Okay, so with that, let us go to the first first what I'll do is I will iterate all the changes that is done, and then I will tell you the challenges with it. Okay, so the first is they have changed the preamble. In the preamble, before it read that the Wildlife Protection Act is basically protection of wild animals, birds and plants. This is what it said previously. Now they have changed it. It is more comprehensive now. They are telling that the objective of the Wildlife Protection Amendment Act 2022 is basically conservation, management and protection of wildlife. Okay, so instead of just protection, they are bringing different words of conservation, management as well as protection. So it becomes a little more comprehensive in terms of the preamble definition of what this act is all about. Okay, that is the first change. The next change is very, very important. They have reduced the number of schedules. Remember, I had asked recently about the schedules, and a lot of people told there are 6 schedules in the Wildlife Protection Act. It is not. Now, from 6 schedules, they have brought it to 4 schedules. Remember this carefully. There are only 4 schedules now. There are no 6 schedules. Now, let me give you what are these schedules. So, you have Schedule 1. This is regarding animals, that is accorded the highest protection. Okay. The next is Schedule 2. These are animals again that are given relatively low protection. Okay. The next is Schedule 3. Here it is basically Schedule 3 is to protect plants. Okay, and the Schedule 4 is very, very important. Schedule 4 enumerates all species of sites, appendix or appendices. Okay, so it talks about the sites, appendices. Okay, so basically let me tell you what it is. One is obviously animals that are given the highest protection like lion, tiger, but there is also one drawback, one criticism telling that too many of the species are now pushed into Schedule 1. That is one. The second is those animals that are put into Schedule 2 but they are given relatively less protection. Schedule 3 is plant protection, so it was actually Schedule 6 in the previous Wildlife Protection Act 1972, but now in Wildlife Protection Amendment Act 2022, Schedule 3 is protection of plants, and the 4th schedule is all those species that come in sites. So sites is basically Convention on International Trade of Endangered Species of both Flora and Fauna. Okay, CITES means again Convention on International Trade on Endangered Species, Flora and Fauna. Okay, now this CITES has 3 appendix. Appendix 1, Appendix 2, Appendix 3. Okay, 1 as highest protection, 2 is highly regulated, and 3 is less regulated. Okay, so all these 3 appendix are put into schedule 4. Okay, now what you should understand is schedule appendix 2 and appendix 3, all those animals that come in appendix 2 and appendix 3 can be used for trade. Okay, according to CITES I am talking about. Okay, so I will come to the challenges and talk next what is it exactly, but now you should just understand that 1, changes in the preamble is done. The second is the schedule has been reduced from 6 schedule to 4 schedules, with 1 being highest. Schedule 1 is animals with highest protection, schedule 2 is animals with less protection, 3 is protection of plants, and 4 is all the species enumerated in CITES, all the 3 appendix. Okay, CITES is Convention on International Trade of Endangered Species of both Flora and Fauna. Okay, so let's go to the third one. The third is implementation of CITES. Okay, so they have created a separate chapter. In this chapter, basically this is a chapter to regulate international trade, and for this what they have done is they have created something called managing authority, and they have created something called scientific authority. Okay, so these 2 authorities are in charge of regulation of international trade on the lines of CITES, that is Convention on International Trade of Endangered Species. Okay, so basically they are in charge of monitoring the export and import of wildlife trade. Okay, they are in charge of this. Okay, this is what is the implementation of CITES put under the Wildlife Protection Amendment Act 2022. This was not there before. CITES is something that is put inside this act. It was not there in 1972. So they have created a separate chapter, not schedule. They have created a separate chapter called Chapter 5B that deals with the regulation of international trade in the lines of CITES. The next is management of wildlife sanctuaries. This is good. What they have done is here they have made the management more people centric. How have they made it more people centric? The reason why I tell you this is they tell that all the wildlife sanctuaries should have advisory committees. Okay, and these advisory committees should have a chief wildlife warden. That is one. The second is it can have members of legislative assembly. Okay, and the third is important. It should also have Panchayat Raj institutions. Okay, so basically it says the wildlife sanctuaries must be managed taking into cognizance the Grama Sabhas. Okay, so Grama Sabhas will also through Panchayat Raj institutions play a role in policy making or policy formulation for wildlife sanctuaries. So that is again making the management of wildlife sanctuaries more people centric. Okay, the next is criteria to declare vermin. Anything is declared vermin, and know this, schedule 1 cannot be declared as vermin, so vermin can only be declared on those animal species that belong to schedule 2. Okay, so those schedule 2 animal species that threaten life or loss of property can be declared as vermin. So once they are declared as vermin, they can be hunted as well as culled. Okay, that is what is vermin. The next is references to Forest Rights Act 2006. Now, management of, in this amendment act, it reads that management of sanctuaries needs to be done wherever possible in accordance with the FRA 2006. This is good. This is very huge. They say the management of the sanctuaries must be done in accordance wherever possible with Forest Rights Act 2006 that recognizes the rights of forest dwellers, inside the sanctuaries. Okay, so this is again a good thing. One more thing they say is here the Grama Sabhas have to play a collective role in protection as well as management. So Grama Sabhas are again coming into the fore. Grama Sabhas have given emphasis here also in the Forest Rights Act of 2006 being in consonance with Wildlife Protection Amendment Act of 2022. It is also being given prominence in the management of wildlife sanctuaries within the sanctuaries, the advisory committees. Okay, so their role within the advisory committees as well as their role from the perspective of FRA is also becoming important. So Grama Sabha has been given relevance in this amendment, as you can see. Okay, the next is the 7th. Permission to carry out subsistence fishing in and around protected areas. Again, this is more human centric. Okay, so all the population in the peripheral areas are given permission to carry out subsistence fishing. Along with this, they have also relaxed the norms so that grazing of cattle can take place. Along with this, they have also allowed drinking water can be extracted from the forests. Okay, for those peripheral communities. So this is another people-centric move. The next is the Amendment Act recognizes the threat posed by invasive species, and for this also they have created something called a scientific authority that will be in charge to look over and monitor invasive species as well as trade in invasive species. Okay, the next is trade of live elephants is recognized for religious purposes. It is recognized for religious purposes and it is allowed only on the basis of certificate of ownership. It is allowed only on the basis of certificate of ownership. That is next. The next is ownership of captive animals and trophies. Here the act says that there cannot be any owner of captive animals. So wild animals especially, captive animals can be surrendered, as well as the trophies can be surrendered voluntarily. They have to be surrendered voluntarily and there will be no compensation given for surrendering it. Okay, so the captive animals as well as trophies must be surrendered voluntarily and there will be no compensation given. Finally, you have prohibition of renewal of license of firearms. Basically, all those people that are residing in 10-kilometer peripheral area of a wildlife sanctuary or a national park will not be given any renewal of their licenses for firearms unless Chief Wildlife Warden authorizes it. So, up to 10 kilometer, no population will get the licenses renewed for their firearms. Okay, and the next is the change in the definition of zoos. Now, the change in definition has become more comprehensive. First, zoos were seen only as exhibition of animals. Now zoos are mainly seen as sites of ex situ conservation. That is one. The second is it is sites of breeding sites, and the third is it is also in charge of rescue centers. It can act as rescue centers. Okay, so these are all the different changes that has been brought in the Wildlife Protection Amendment Act 2022. To summarize the entire thing, one, they have changed the preamble. It has become more comprehensive by adding the word conservation, protection as well as management. 2, schedules are changed from 6 schedules to just 4 schedules. 1, animals with highest protection. 2, animals with least protection. 3, protection of plants. And 4, all those species enumerated under sites. Appendix 1, Appendix 2 and Appendix 3. These are the 4 schedules. The next is the implementation of sites. There is a separate chapter and institutions are created to regulate the international trade that is all those species enumerated under sites. The next is management of wildlife sanctuaries and advisory committees to be created, and Panchayat Raj institutions are getting a voice to manage wildlife sanctuaries. The next is criteria to declare vermin. Vermins in 1972 was in Schedule 5. Now there is no schedule as such, but any schedule to animals can be declared as a threat to life or property and can be declared vermin which can be killed, hunted and culled. The next is reference to Forest Rights Act 2006. Wherever possible, this act must always act in accordance to Forest Rights Act, which upholds the rights of forest dwellers and tribes, scheduled tribes, which is again a very humanitarian provision. The next is permission to carry out subsistence fishing as well as livestock cattle allowed grazing, as well as drinking water can be taken. The next is invasive species are recognized, and there is an institution to look after that invasive species trading as well as the introduction into the ecosystem. Next is trading of live elephants is allowed in religious purposes. However, that certificate of ownership is a very important necessity. Next is ownership of captive animals is not allowed, so they have to surrender voluntarily, and there will be no compensation. Prohibition of renewal of arm licenses, especially in those population that is living within the vicinity of 10 kilometers from the wildlife sanctuary or a national park. Then is the change in definition of zoos, which are become more comprehensive in nature. Okay, so these are some of the changes that are done within the Wildlife Protection Amendment Act 2022. What are the challenges? The first challenge is several important topics are left out. One important topic that is left out is human-animal conflict. How are we going to address that? This is not given there. What will be the impact of climate change on wildlife? This is not addressed in the Act. This is some of the challenges. The next is this new Schedule 4 and this Chapter 5B. That is, they are giving more prominence to sites. See, what is happening is this Wildlife Protection Act is basically restrictive in nature. That is, you are trying to be restrictive in protecting this wildlife. However, sites is more about regulatory, and it is more about allowing international trade of exotic wildlife. See, both actually speaking have a very different objective. So by integrating sites into the Wildlife Protection Act, you are trying to contradict oneself. On one hand, you are trying to conserve the wildlife and making sure that these wildlife are protected and conserved. On the other side, you are allowing trade to happen amongst this wildlife. So when trade happens amongst this wildlife, the protection criteria will be reduced. So there is one school of several environmentalists who say that this sites chapter itself should be completely removed from the Act. That is another challenge. The next is elephant trade is legalized. This is done for religious purposes, but this can lead to exploitation. That is another challenge. The next is laxity in declaring invasive species. What they have done is, in this Act, they have declared that any species that is not native of India is declared invasive. This is wrong. This is wrong definition of invasive species. Any species that is not native of India is exotic. It is not invasive. So anything that is not native of India is exotic. Only if exotic will start hindering or hurting the native ecosystem, only then you can term those as invasive. Okay, so this definition of invasive species in the Act is wrong. The next is vermin. They say that any Schedule 2 animals can be declared vermin if it poses a threat on life and property, but the criteria is not defined in detail. That is another problem. The next is marine wildlife. You should understand that marine wildlife is protected in India under coastal regulation zone, right? However, marine wildlife trade is allowed under sites. Now, sites is put under Wildlife Protection Amendment Act 2022. Here, you are allowing through sites the trade of wildlife species. However, the regulation is done in some other act. So again, there is a contradictory in bringing sites into this particular legislation. So these are few challenges in the Wildlife Protection Amendment Act. But as you saw that several amendments are people centric, it is progressive, but it is very much necessary for us to bring the new challenges like human animal conflict, which we are seeing rise in cases in the entire length and breadth of the country, as well as the impact of climate change on wildlife. That is another important issues. Marine wildlife, this is again important issue. So all these things must again be debated, and then amendments must be done within the act so that these things are also addressed. Okay, so these are the important issues of today. I hope you liked it. Please make sure that you like, share and subscribe so that I am also motivated to do this on a regular basis. Thank you guys. I hope you enjoyed it. See you tomorrow. Bye.